going to be referring to the Commonwealth of Massachusetts Energy Facilities Siting Board final decision in case number Massachusetts EFSB 13-1. It's in the matter of Footprint Power Salem Development LP. I'd like to move that as a full exhibit as OER 4.
Is there objection?
No.
CLF has no objection.
Submitted for.
Thank you. And I have passed out copies to the board and to the parties, and I'd like to give the witness a copy of the decision as well. Thank you. Mr. Feinblatt, I'm looking at your pre-filed direct testimony, page 26.
Okay.
You discussed the Resilient Rhode Island Act. Could you explain to the board your understanding of the act?
The Act establishes goals to reduce greenhouse gas emissions over time.
And you also mentioned that there are several specified target dates. Are you aware of what those target dates and those targets are?
Not off the top of my head, no. I am generally aware of them.
I have a copy of the Resilient Rhode Island Act. I believe I gave you a copy. Do you have that in front of you?
I do.
In section A2 of the act, it goes through the targets. Do you see that?
I do.
And could you say what the target is for 2020?
10% below 1990 levels.
And for 2035?
45% below 1990 levels.
And for 2050?
80% below 1990 levels.
Thank you. In your opinion, which of those three targets would require the highest degree of action to meet? Or in other words, which target would you say would be the most challenging to meet?
I would say C.
And on page 5 of your testimony?
Chairperson, I want to note for the record that Mr. Feinblatt was not Invenergy's witness on carbon emissions. That was Ryan Hardy. CLF doesn't object. We can go down this road, but I think OER is asking the wrong Invenergy witness these questions. We don't object.
We don't have any objection with OER asking this witness these questions, that he does reference some of this in his direct and rebuttal testimony.
Thank you.
Thank you. On page 5 of your testimony, you indicated that air emissions are generally evaluated on a regional basis. Is this true for greenhouse gas emissions?
It is.
And why is that?
Because it's a regional market. When ISO New England dispatches energy, it considers all the resources in the market. And the emissions transport from state to state. They don't remain within state borders.
If the emissions travel from state to state, and it's better to evaluate emissions based on a regional basis, is it fair to say that reducing greenhouse gas emissions will require regional effort?
Yes.
Are you aware of any other states in the region that have a law similar to the Resilient Rhode Island Act?
I know Massachusetts has the Global Warming Solutions Act.
If Massachusetts fails to achieve its greenhouse gas emission reduction goals, will that have an impact on other states in the region?
I mean, I think in a lot of ways these goals are really just accounting. So if Massachusetts doesn't reach its goals, you know, I don't, there's no physical impact on other states. I guess I'm not really sure what you're asking.
In general, if Massachusetts goals on emission reductions, let's say in reality they don't meet their emission reductions, would that have an impact on Rhode Island and other regions, given that the emissions travel through state lines?
Well, I guess, yeah, so I guess I would say that the emissions won't be as low as they would be if they had met their goals.
And the same would be true for Rhode Island's targets. If Rhode Island doesn't achieve its targets as contained in the Resilient Rhode Island Act, the impacts would extend out beyond Rhode Islanders.
There would be fewer emissions than if they had achieved their goals, yes.
But in asking, you're answering this question kind of in a vacuum. I mean, if Mass reduces their emissions, that doesn't necessarily mean emissions in the region are reduced. Isn't that correct? Because to the extent that they're reducing them, someone else is meeting the demand.
Right, but it's just, I guess they're not just meeting their goals by passing it off to another state. I mean, there are other things that they're doing to reduce their emissions. So I guess I don't look at it as a zero-sum game. I think all states could reduce their emissions. There's different ways to reduce them.
True. I guess I'm just looking at the juxtaposition between a state and a regional frame on this.
Right, so I would say if any state in the region reduces its emissions, it's good for the entire region.
Well, Rhode Island commented on the Global Warming Solutions Act, concerned that a cap and trade within the state of Massachusetts might actually result in other states increasing their emissions to make up for the energy that was needed. But I'll take your point. Cumulatively, if every state reduces emissions, we're going to have a regional reduction. I think that's your point. Am I right?
Yes.
And to your point in Director Coit's questioning, it would take a regional effort to achieve the purposes of the Resilient Rhode Island Act.
Well, I think it really comes down to achieve the purpose, but whether it achieves the specific, accounting included in the act would depend on the specific numbers, I guess. There's the numbers, and then there's what's really happening,
right.
I guess.
Yeah, I'm putting the numbers aside. Let's put the accounting aside. Let's just talk about the general purpose of the Resilient Rhode Island Act and the general purpose of the Massachusetts Act, which is to ultimately reduce greenhouse gas emissions. To achieve those goals, it would have to take a regional approach, given that the emissions cross state lines.
True, I agree.
Back to your testimony on page 26. On line 16, you state that it is important to consider that the average CO2 emission rate from CREC will be at least 48% less than the average CO2 emission rate in Rhode Island from power generation in 1990. And at least 10% less than the average CO2 emission rate in Rhode Island from power generation in 2014 on a pound per megawatt hour basis. Why do you consider this statistic important to consider?
Because it's our belief that when CRC operates, other power plants within the state will operate less. So you're generating megawatt hours with significantly fewer emissions.
Last week, I don't know if you were listening to the testimony, but Mr. Hardy showed us a figure. It's in Invenergy 37D. Right, yep, that bubble chart.
And we're getting a new bubble chart, correct?
Yes, it's being worked on.
It is being worked on. That one, I think, correct point, Mr. Hardy mentioned that it takes a little bit longer, but
It's on page 21 of Mr. Hardy's December testimony.
We're all working on getting that up.
And I'll give you a minute to look over the chart.
Okay.
Does this figure, is it consistent with what you're saying here about correct replacing higher emitting plants over time?
Yes. I mean, the emissions of CO2 from a power plant are directly proportional to how much fuel the power plant has to burn to generate that electricity. So if you have a plant that can generate electricity firing less fuel and having lower CO2 emissions, for every megawatt hour that it generates, it can generate at a much lower CO2 emission rate than those less efficient resources. And that's shown graphically in this bubble chart.
And right now, we have a lot of larger bubbles towards the end of their age, well, not toward the end of their age, but upper in age, as you can see in the 50s, 60s, 70s. There's bigger bubbles than the plants that are in the ages of just beginning or 10 to 20 years old.
Correct. So those differences would be even more dramatic if CRC were to displace the operation of one of those plants. At least the data that I had put in my testimony are based on the average. And certainly those plants at the higher age vintage would be well beyond the average. So those percentages less than the average emission rate would be significantly more dramatic.
Right, so using the concept that CREC would be replacing higher emitting plants, the impact would be larger if the plant it's replacing has a bigger bubble in this chart, essentially.
That's correct.
So as we move on in time, this is ages in 2024. If we envision what this chart may look like in 2035 or 2050, which are target dates, essentially the chart would move to the right and there would be new plants coming in, and as we add in, this is just the thermal generation fleet, but as we add in perhaps other generating facilities and renewable energy facilities, and we push this chart to the right, the impact of replacing less efficient plants wouldn't be as great. So correct.
That's correct.
Mr. Mercaccio, just because it's hard to visualize, sometimes you're sort of cutting off the right side and saying the bigger bubbles will go away and more small bubbles will be on the left. Is that what you're saying?
Right, just a general
Okay, or asking about,
yeah,
okay.
high terms if we, because this is age in
Yep.
2024, as we go age in 2050, you know, we push that over.
Right. And the point too is this is just the thermal, so we're not seeing any of the renewable energy facilities or nuclear on this. Correct, Mr. Feinblatt?
Correct.
Are you familiar with the settlement agreement between the Conservation Law Foundation and Footprint Power Salem Harbor that's contained within the decision that's marked as OER Exhibit 4?
I am generally familiar with it, yes.
Could you give a high-level explanation of your understanding of what the settlement agreement does?
Well, as it relates to CO2 emissions, the settlement includes a date certain when the plant would shut down, so it would cease to have CO2 emissions. And it also has a annual cap on CO2 emissions that declines over time, but includes provisions for allowances to be generated in years in which the plant emits less than its cap of CO2 emissions that can later be applied to the cap, so that each year they would have the ability to emit more than the cap using those banked allowances. Those banked allowances are not banked on a one-to-one basis. They're on sort of a declining basis, so the further out you go, the less valuable that those banked allowances become.
You're using the term banked allowances, but this is talking about the Global Warming Solutions Act, for which there were no regulations at that time. So can you clarify what you mean by banked allowances?
Well, I guess, sorry, the term that's used in here is offsets. So yeah, which is essentially the same concept, but so it has a provision for the facility. So the facility has a cap every year of the tons of CO2 emissions it can emit. But if they emit less than that, that difference becomes an offset. It can then be applied in a future year. So that if the cap is, just speaking in general terms, if the cap is 3 million in year one and they only emit 2.7 million, that 300,000 tons of CO2 can then be used as an offset in a future year, so that they can go over the cap in a future year. So ultimately, it's sort of a mini version of RGGI for a single facility.
In conformance with the Global Warming Solutions Act standards, correct?
I don't know what relation this has to the Global Warming Solutions Act.
Just for the record, Director Coit, if you look at pages 4 and 5 of the agreement, that's where this is addressed.
I am looking at pages 4 and 5.
Mr. Feinblatt, sorry. On page 3 of the settlement, there's whereas clauses. And in the fourth whereas clause, it says, whereas facility has been designed as an efficient and flexible generating solution capable of supplanting less efficient, more highly polluting facilities, and includes quick start capabilities that may provide reliability services or firming support for renewable energy resources, a critical element of reaching the GWSA 2050 mandate. In this case, the facility here would be footprint power.
Correct.
Would you say that CREC has been designed as an efficient and flexible generating solution capable of supplanting less efficient, more highly polluting facilities, and includes quick start capabilities that may provide reliability services or firming support for renewable energy resources?
Yes, I would.
Also in the whereas clause above that, the third whereas clause, I'll ask you to read this clause. Could you read the third whereas clause?
The parties agree that the conditions established in this settlement agreement, including the adoption of declining annual carbon dioxide emission limits and a limitation on the useful life of a facility, represent the types of threshold conditions that may permit new fossil fuel infrastructure, including generating facilities, to demonstrate compliance with the GWSA including the GWSA's 2050 mandate.
What is your opinion on this clause? Do you believe that to be true?
I do that the intent of the agreement is consistent with the GWSA mandate. It just seems that there are so many ways that offsets could be generated. Again, I'm only generally familiar with this. I don't know if this were to be applied more globally, how much impact it would actually have.
And that clause talks about the useful life. Is it your understanding that and if we go back to that chart on page 4, the emissions end in 2049. So is it your understanding that this settlement would end the useful life of the facility by 2050?
It does, but it also says unless otherwise required by law. So I think it leaves an opportunity for something to happen to allow it to continue to run.
Right. And that 2050 date is that significant?
It's consistent with the Global Warming Solutions Act goals.
And the Resilient Rhode Island Act, does it have the same goal in the
Yes.
same target year as
Yes.
the
Yep.
global warming?
Yep.
Has Invenergy ever asked you for your opinion on the application of a declining annual CO2 emission limit for the proposed CREC?
They have not.
How about a limitation on the useful life of the proposed CREC?
They have not.
In your opinion, would a declining cap similar to this one help Rhode Island meet its 2050 emissions target?
It could, but I don't think it's certain that it would.
How about, in your opinion, the end of the useful life being 2050? Would that help Rhode Island meet its 2050 emissions target?
I guess I'd give the same answer that it could, but it's not certain that it would.
Thank you. I have no further questions.
When you say it's not certain, what other factors are you thinking of?
Again, just this ability to generate offsets. So it's not clear whether, I can only put myself in Footprint Power's head to say that if I would have agreed to this, I would have made sure that I could still have the flexibility to operate my plant in the way that I felt that I needed to. So when I see all these different provisions of ways to generate offsets, again, it just makes me wonder whether they would still retain the ability to operate at the level they would have liked to right from the beginning. So it sort of appears as if there's a decline, but I don't know in reality if that will actually happen because of all the offset provisions.
But wouldn't it be true under this settlement that if the plant didn't meet, I guess I haven't read it in enough detail, but the way the settlement works, you either meet the target or you have to offset it, correct?
Correct.
So if you couldn't offset it, presumably you wouldn't be in compliance with the settlement agreement.
Correct.
In which case, what would happen?
I'm not sure. I haven't focused on that aspect of it. But again, if the caps in initial years are set at levels that the plant never intended to run. Again, I don't know that they are or that they aren't. I'm just giving my opinion of the agreement. That could allow them to bank quite a few offsets in those early years when the caps are high that they could then possibly apply in later years and allow them to continue to operate at the same levels. You know, it's just sort of a math problem for footprint power to figure that out. I don't know, what their intention is in terms of how much they plan to operate in the years, right? Again, it's not these are not firm caps because of the offset provisions. So I have to believe that they've had some ability to structure them in a way that doesn't inhibit their operation.
Chairperson, CLF would like an opportunity to cross-examine this witness on the new exhibit.
Go ahead.
I would just say so, and subject to the proviso that you pointed out that he's not the greenhouse gas emissions.
I understand. Good morning, Mr. Feinblatt. My name is Jerry Elmer. I'm a lawyer for the Conservation Law Foundation.
Good morning.
Were you aware in advance of this morning that you would be asked to comment on the footprint settlement?
Yes.
How did you become aware of that?
I was told by Invenergy.
And do you know how they were aware of that? Were they in communication with OER's lawyer?
I don't know.
What did Invenergy...
If I may, I'm sorry to interrupt. If I may, for the record, we were advised by Mr. Mercaccio that he was going to seek to introduce this document and would be asking questions of the air emissions witnesses. Mr. Mercaccio, can you explain?
Chairperson, I sent the same email at the same time to all the parties.
And what was said to you by Invenergy's counsel concerning this settlement?
Objection privileged.
No, there's no attorney-client privilege here. This is a hired expert witness.
We'll go with work product,
My question stands.
as does my objection.
State the question again. Why wouldn't that be work product?
I'll withdraw the question. Are you aware of the fact that this settlement came in a lawsuit brought by CLF that was challenging the permitting of the footprint power plant?
I'm generally aware. I don't know the details.
Okay, let me direct your attention to attachment 4 to the settlement. It says in the upper right-hand corner, page 9, but it's not numbered consecutively from the cover document. Do you have that?
Yes.
That says settlement agreement between Conservation Law Foundation and Footprint Power Salem Harbor, is that correct?
Yes.
And if you look 2 pages later at the whereas clause at the top of the page, it says CLF has challenged the legality of the EFSB final decision. Do you see that?
I do.
Okay. So you understand that this was a settlement in a lawsuit that Conservation Law Foundation brought pursuant to the Massachusetts Global Warming Solutions Act, which you're referring to as GWSA, is that right?
That's right.
Objection. Asked and answered.
Are you aware of the fact that an important difference between the Massachusetts GWSA and the Rhode Island Resilient Rhode Island Act is that the GWSA in Massachusetts has mandatory carbon emission reductions, and the Rhode Island Resilient Rhode Island Act has aspirational carbon emission reductions?
Yes, I'm generally aware of that.
Are you aware of the fact that a difference between the footprint power plant and the Invenergy power plant, proposed Invenergy power plant, is that the footprint power plant was designed to go on the locational site of a closed coal-fired power plant, and the Invenergy power plant is scheduled to go on what is now a forest.
I am aware of the Salem Harbor plant, but I would not characterize this site as that CRAC has proposed for as being forest. There's a compressor station on the site.
I was deliberately not saying the footprint of the Invenergy site, but I guess I'll have to go back to that. Are you aware of the fact that the footprint project in Salem, Massachusetts was built on the site of a previously existing power plant?
Yes.
But the Invenergy footprint is to go on an existing forest?
Yes.
Okay. Are you aware of the fact that there was, let me try that again. You're aware of the fact that there was a coal-fired power plant at the footprint site in Salem, Massachusetts before the footprint plant, is that right?
Yes.
And are you aware of the fact that when the owner of that coal-fired power plant filed a delist bid with ISO New England, ISO New England did not accept the delist bid because the ISO believed it needed a generator that was geographically proximate to the Boston load pocket?
I'm going to object to this question. It's outside the scope, and it's assuming facts, not evidence.
Do you believe that there are geographical differences between the location of the Salem Harbor footprint plant and the proposed Invenergy plant in Boroughville?
Can you clarify what you mean by geographical differences?
That they interconnect to the ISO New England grid at different locations.
Yes, I can agree with that.
The date of the footprint settlement is 2014, is that correct? February 25th, 2014 on the cover page.
Looks like the effective day was the 18th day of February 2014. Page 1.
Okay, so that's approximately 5 years ago, give or take a few days.
Yes.
And I have no further questions.
I have nothing, thank you.
Thanks. I do have redirect. I thought we were going to break at 12:15. If not, I can start.
We can get started.
Sure. Mr. Feinblatt, in regards to the air permit application that ESS files, who makes the decision on the permit?
Ryder.
And anyone else in that process as a decision maker except for RIDO?
No.
And do you know what the standard is before this board in terms of environmental impacts?
The burden is on the applicant to demonstrate that the proposed facility won't cause unacceptable harm to the environment.
And that's set forth at Rhode Island General Laws 4298 11B3, correct?
Correct.
I'd like to go through, in terms of the air permit process. We've talked a lot about it in bits and pieces. Can you describe for the board what the air permitting process in Rhode Island consists of generally in this situation?
Yeah, so in Rhode Island, when you're applying for a major source air permit, the application has very specific elements it has to include. Generally, the first step is to define the potential emissions of the facility. So you have to take every emission source, identify all the emission sources of the facility, and identify all the pollutants that each source will emit. And then you have to assume that the source will operate 24 hours a day, 365 days a year at its full load. And if it ran at that full load 24/7, 365, if every emission source ran at the same time for all that time, what would the potential emissions of the facility be? So this is before you apply any controls, this is before you apply for limits on operation. And that number, those numbers will basically dictate, first of all, whether you need a permit, and then secondarily, whether you need a minor source permit or a major source permit. So in a case like Invenergy, you do that potential emissions application calculation, and if the potential emissions exceed the major source permitting thresholds, then you have to apply for a major source permit. First thing you need to do is demonstrate that the facility will meet all applicable state and federal air pollution regulations. So you have to go through every state regulation and every federal regulation that could apply and explain why it does or doesn't apply and in what way, and then also go through in what ways the plant will comply with those applicable requirements. So you have to look at every single regulation. And then there's the air quality, there's the control technology analysis that we talked about, the back layer analysis, where you have to identify for each source and each pollutant every available control technology. For each available control technology, determine how effective it would be to determine what the best available control technology is, and achieve the lowest achievable emission rate as well. And then there's the air quality impact analysis, which is the model analysis we talked about, where you look at the emissions from the facility in concert with other facilities in the area to see if its emissions will cause any exceedances of the air quality standards. Rhode Island also has an extremely strict air toxics rule, Regulation 22, which requires you to look at all of your air toxics emissions and then also model to see if you are in compliance with the acceptable ambient air limits for each of the air toxics emissions that you're going to emit above thresholds. That's a very rigorous analysis that's unique to Rhode Island. And then Rhode Island also requires the health risk assessment, which is unique to large sources like the CREC plant, where you have to sort of apply your modeling to specific. There's a CARB program developed by CARB, the California Air Resources Board, that specifically takes your modeling results and applies it to specific acute and chronic health effects that those emissions could have. So that's what the health risk assessment shows. So, once you've gone through all the regulations, you've identified the control technologies, you've done your modeling, you've done your air toxics modeling, you've done your health risk assessment modeling, all that gets packaged into an application, you submit to RIDA. There's generally quite a bit of back and forth, questions, meetings, comments, to get to the point where RIDA's ready to issue a draft permit for public comment. So the draft permit will go out for public comment, there'll be a public hearing, and then RIDA will review all of the comments it's received from the public, and ultimately come to a final decision. So it's a very, very rigorous process. It's very prescribed, but very rigorous. And at the end of the day, it's all designed to ensure that the emissions from the facility are being controlled to the maximum degree that's technologically available based on the type of source that it is.
And upon
Okay, I think we can break.